Hello, and welcome to this audio podcast on the topic of trading plans and SEBI proposals on amending regulations relating to trading plans for insiders. This audio podcast will be done by my colleagues Anurag, Shah, Sach, Chabria, and myself, Ratnadeep Roychowdhury. To set the stage, it's relevant to briefly describe the regulatory regime governing insider trading and unpublished price-sensitive information for listed companies. So, the overall regulations, regulatory framework is governed by the SEBI Prohibition of Insider Trading Regulations 2015, as supplemented by provisions of SEBI ICDR. And various circulars and notifications issued by SEBI from time to time. Now, the underlying purpose and the underlying logic of all of these regulations is to ensure that there is no significant information asymmetry in the market. So, all participants in a listed space should ideally have the same level of information about a listed company and its prospects when deciding to buy or sell. However, in practical reality, obviously, simultaneous symmetry of information is not possible, and it is acknowledged by the regulator that there will be certain individuals and participants in the market who, by their very nature and their duties, will have prior knowledge of developments in relation to a company. These would include the officers, the directors, the employees of a company, and could also include important advisors to the company, could include certain regulators who would be privy to certain developments in the company, and all of them are typically classified as insiders. Now, the overridings and overarching logic is that an insider who has an advantageous position on account of his preferential access to information about the company should not be able to profit from that advantage to the detriment of other participants in the public market. So that he, basis his additional knowledge, should not be able to trade while he is in possession of knowledge not available to others. To that extent, the regulations prohibit insiders from trading in the shares and securities of the company whilst in the possession of UPSI or unpublished price-sensitive information. However, it is also true that these insiders, especially directors and employees and other insiders related directly to the company, often hold a large portion of their wealth or receive a large portion of their remuneration in the form of shares and stocks of the very company that they are employed at or which they are governing. So it is also important that these critical players and these critical personnel at these companies are able to realize the value of their remuneration or of their assets by liquidating shares of the company. So therefore, to balance these potentially conflicting imperatives, one of protecting information symmetry in the market and enabling these important players to realize their remuneration, SEBI in its insider trading regulations have provided several exceptions to the general rule prohibiting insiders from trading while in possession of UPSI. The one that we will be focusing on is the form of trading plans. Trading plans fundamentally is a declaration of intent by such insiders to transact in the shares of the company within a specified time period so that such insiders are then bound to make those transactions irrespective of what the market dynamics are on the relevant date. This has the dual benefit of permitting the insider to realize and liquidate his shares, while at the same time not allowing such insider to profit from his additional information access, since he is bound to a course of action irrespective of how the UPSI once released in the market influences the price. This is the overall context of trading plans, and now I will hand over to my colleague Anurag to speak about it in detail.
So the trading plan under the current PIT regime operates in the following manner. So the first step is that an insider who has access to UPSI and intends to, as my colleague Ratnadeep mentioned, intends to liquidate his positions or possibly acquire further more shares, would require to furnish this trading plan in front of the compliance officer. Now, for his approval. Now, this furnishing of the trading plan would mandatorily be needed to be done 6 months prior to the point where such trades are intended to be executed. Now, how this works is that the insider would furnish this trading plan to the compliance officer, and once the compliance officer has granted its approval to the trading plan would be disclosed publicly. 6 months from the date on which the trading plan has been disclosed publicly, the trades in the trading plan would not be done. It would only be done after the 6 months period. Now, this is in general parlance considered as a cooling off period for the trading plan, and the intention behind this 6-month restriction is to ensure that the UPSI that was available to the insider at the time of formulating the trading plan has become generally available information in the public until the time such trading plans are actually executed. Now, once the trading plan is formulated, there are also certain restrictions with regard to how the trading plan will be executed. The very first restriction is that under the current regime, the trading plan needs to be mandatory for a 12 months period, and it cannot be for a period below 12 months. So the plan formulated has to provide positions or purchases or trades that will be undertaken for a period of 12 months starting from the last date of the cooling off period. So next restriction is a blackout period during which trading plan executions cannot be done. So once the trading plan has been approved and the cooling off period is over, the trading plan cannot allow for a trade in a period which is within the blackout period. Now, this blackout period is considered as a period between the 20th trading day prior to the last trading day post which the financial results of the listed company will be announced, and the second trading day post the announcement, until the second trading day post the announcement of such financial results. So during this blackout period, there cannot be any trades which are envisaged in the trading plan itself. The third restriction that is imposed on a trading plan is that the trading plan shall not have any overlaps with any other trading plan, and you cannot have more than one trading plan operating in the same tangent. So I cannot have 2 trading plans for the same period wherein I am executing trade as an insider. Fourth is that while furnishing the trading plan to the compliance officer for his approval, an insider will have to provide the value, number, frequency and interval in the trading plan on how these trades will be executed. And finally, the fifth one is that under the current regime, these trading plans are irrevocable, and once approved and publicly disclosed by the listed company, these trading plans have to be mandatorily implemented, and they cannot be non-implemented. Now, another thing which my colleague Sach will go over is that there's a construct of contra trade under the PIT regulation, which basically requires that once an insider has executed a trade, a contra trade or a reverse trade for that particular trade cannot be executed for a period of 6 months. Now, this restriction is under the current regime is only applicable on trades which are done through pre-clearances during a trading window closure, and is not applicable on a trade which is done through trading plan, which has also been changed in the current regime, which my colleague Sach will take us through. So this is the current regime of the Indian PIT regulations, but it is also very important for us to see how different and other regulators are regulating the same, for which a very good example which has also been relied by the working group of SEBI is the SEC jurisdiction in US. So under the SEC jurisdiction, the same trading window or trading plan construct finds itself in the SEC jurisdiction also in the form of a window period and a trading plan. So in the US trading plan construct, the approving authority, while it is the chief financial officer of the company, the trading plan itself would require the insider at the time of furnishing the trading plan to furnish either the price and the value at which the trade shall be executed, or an algorithmic formula or a formula based on which the price should be determined and the trade shall be executed at those prices, or the insider could give the right or the power of attorney to execute these trades to a third party, wherein such third parties shall execute these trades based on their commercial knowledge. Now, these are the three parameters within which the trading plan can be formed and predetermined as to when the trade shall take place. In case if the insider is setting a benchmark through either of these parameters and those benchmarks are not being set, the trading plans will not be executed, because an insider is providing these parameters and benchmarks prior to the approval of trading plan itself. One another key aspect which is very different from the Indian regime under the SEC regime is the cooling off period that we discussed. So under the Indian regime, the cooling off period that stands as of today is a 6 months period during which the trading plan will not be implemented from the date when the trading plan is made public. So 6 months after the trading plan becoming public is when my trading plan actually starts being effected. In the SEC jurisdiction, this cooling off period is only for 60 days, which is after 60 days from the date when the trading plan is approved by the CFO of the listed entity. Post 60 days, that trading plan can start to get implemented. This is a very key difference from the current regime, because the underlying construct remains the same in both jurisdictions as to what is the relevant period within which a UPSI should become generally available and post which such trading plans can be executed. Now I'll hand over to my colleague Sach to take us through the changes that has been proposed by SEBI's working group.
So since the introduction of trading plans in the Prevention of Insider Trading regulations in 2015, a lot of market feedback as well as empirical data has suggested that the current regulatory regime for these trading plans are onerous. So for example, in the year of 2022 to 23, the figures on National Stock Exchange show that only 12 trading plans have been disclosed by insiders, which when we look at the number of listed companies as well as insiders in India and we compare this to those numbers, the number of trading plans is extremely low. Hence, the terms of reference given to the working group was to facilitate and increase the adoption of these trading plans by persons who may be in possession of the UPSI. Therefore, the working group has made several proposals to the restrictions that Anurag had specified in order to ease the provisions of the trading plans. The first is the cool-off period of 6 months have been reduced to 4 months, keeping in mind that the market is extremely dynamic, and for insiders to plan for 6 months ahead, it may be very onerous, because when at the point they're implementing the trading plan, the market conditions may be very different from the time it was formulated. This ties up with a minimum period of the trading plan, which is for 12 months. Again, keeping in mind the dynamic nature of the market as well as a lot of black swan events that have occurred in the past few years, such as COVID, it is a very long time to sit and plan ahead, and flexibility will be needed in case insiders want to sell within a shorter period as well. Hence, the working group has proposed making this period 2 months instead of 12 months in order to ensure insiders can effectively plan their trade in advance considering the prevailing market conditions. Therefore, under the new proposals, the cool-off period will be 4 months and the trading plan will be 2 months, which means you will have a period of 6 months as opposed to the previous period of 18 months that was there under the current regime. Another change that was proposed is that the blackout period is done away with. This is keeping in mind that the blackout period forms a significant portion of the year during which no trades can be undertaken by the insider. Therefore, there are very few trading days in the entire year for them to plan their trades. Keeping in mind that there is a cool-off period already and the insider is not allowed to alter the trading plan once it has been approved and disclosed to the public, the working group has proposed doing away with this blackout period. Another thing is that the trading plan, once approved, is irrevocable. There are no deviations, and it also does not allow the insiders to set price limits. This again ties up with the dynamic market because in case there is some event wherein market conditions may be impacted, say for example there is a war and the selling price of the shares may reduce exponentially. Because of the nature of trading plans as is currently formulated, the insider will have to continue with the trade even though it may be economically disadvantaged to them. Therefore, the working group has proposed setting price limits and have introduced price limits based on a fixed percentage threshold at 20% of the current market price, which was at the date of submission of the trading plan. Therefore, for example, if I'm making a sale trade and my shares fall 20% below the price that I have set, the trade will not continue post that time, and the working plan will not be implemented as the price limits have been breached. Finally, the exemption from contra-trade provisions that are currently available under the trading plan, as explained by Anurag, has also been done away with. Contra-trade restrictions now will be applicable on trades executed under trading plans, keeping in mind that it's difficult to envisage a genuine need for any insider to plan in advance two opposite trades within a gap of less than 6 months from each other. Finally, the disclosure of trading plan, there was no deadline that was proposed under the current framework to disclose this to the public. So for the sake of clarity, SEBI has proposed, the working group has proposed a deadline of 2 days post the approval of the trading plan in order to add more clarity to the procedure. Ratnadeep will take us through our final views on the working group consultation paper.
So, concluding this particular podcast, we wanted to set out three principal observations on this development. Firstly, we think it's a fantastic move by SEBI to acknowledge the legitimate needs of these key insiders of listed companies, because it's only when key insiders perform that listed companies perform, and therefore the broader market performs better. So it's a great development that initiative that SEBI has undertaken, and we hope that the majority of these proposals find their way into amendments to the insider trading regulations. The second point we wanted to make was that on the duration of the cooling off period, which presently is proposed to be reduced from 6 months to 4 months, here we believe that this is a rather conservative approach, since most of the insider trading regulations and other ICDR provisions require in UPSI or unpublished price sensitive information to be disseminated to the market in a very short period of time. In certain cases, within 15 minutes from the conclusion of the board meeting to within 24 to 48 hours from the event occurring or the management becoming aware of it. By and large, we believe that a period of 30 days, as has been adopted by the SEC, would be more in line with balancing both the need of information symmetry as well as the need for insiders to liquidate. For example, insiders may well have a pressing need for liquidity which cannot wait for 4 months. And since, as we have mentioned before, such shares often form a large part of their wealth pool, it would not be fair, we believe, to lock the same up for a period of 4 months. The third and last point that we wanted to make was again in terms of the positive step taken by SEBI to allow for certain exits from the trading plan, which today is limited to the insider specifying a price range of plus minus 20% from the price on the date of formulation of the trading plan, being the trigger where he does not need to execute the trade. Again, we feel that this is on the conservative side, and as long as the discretion is surrendered by the insider, there should not be any numeric restriction such as plus minus 20% limiting the insider's ability to not execute the trade. And in this regard, again, guidance can be taken from the SEC options, such as specifying a formula upfront or leaving the discretion to a third party entirely, to permit greater flexibility to the insiders. So these are our 3 concluding thoughts. With that, we bring this audio podcast to a close. Thank you.